Interpretation of statutes. Today in this session we will start by discussing first of all what is the purpose of interpretation of statutes, and then we will discuss what are the various types of statutes as the slide mentioned here. What are the various types of statutes in detail that is there. So let us begin by understanding what is the main purpose of interpretation of statutes. As stated, where the words are clear and there is no ambiguity and the intention of the legislature is clearly conveyed, then there is no scope for court to take upon itself the task of amending or altering the statutory provisions. However, when the same is not clear, interpretation is done by the judges. So it states that whenever any legislation is clear and there is no uncertainty regarding its meaning, regarding its provisions, all the legislature, the words, the meanings is clear, then as it is the legislature is applied in the given facts that is there by the judges. But if the same words are not clear and there is ambiguity as to what is the actual meaning of the legislation, of the words of the legislation, or what was the true intention, to find out the true intention behind the legislation, then what judges do? Judges interpret the particular legislation. तो इंटरप्रिटेशन एक हमें इसीलिए करना होता है ताकि हम अपने जो हमारा एरिया है उसको हम बढ़ा सकें, उसको हम इंक्रीज कर सकें और जो जस्टिस है वो मिले, ताकि जो वर्ड्स लिखे हुए हैं उससे हम आगे बढ़ के भी उससे हम उसके ट्रू मीनिंग और ट्रू इंटेंशन को समझें और उसके बाद हम जस्टिस करें. So the purpose of interpretation of statutes is to help the judges to ascertain the intention of the legislature. We have discussed this many times, that the purpose is to help the judges कि वो they understand, they find out the true intention behind the legislation and why was the legislation enacted in the first place, and they act according to the intention behind the legislation. Now the necessity of interpretation would arise where the provision gives the object of the statute. Now we can say that whenever why interpretation is required as such. The first of all is they help the judges to give justice, to provide justice. Now second of all, it is most important that any legislation should be in consonance, should be in the lines of justice. If that is not happening, if the main object of the statute is getting defeated because of the words, because of the way the words or the legislation is being written down, then interpretation is required. So it is not necessary that in present times I may frame a rule, I may write down something which is a rule or which is an act applicable today, and from today, applicable from today, I may write down a rule. But there may arise some peculiar cases, say 10 years down the line, 5 years down the line. So the way I have written that particular rule today may not exactly be applicable 10 years or 5 years down the line. So in that case, if the matter comes 5 years down the line, then if the judges won't interpret what I have written today, then the main object behind the statute would be defeated and they won't be able to provide justice. So that is why interpretation is important, so that the main object of the statute, that is to provide justice, is not defeated. Now there are certain cases, what we'll do, we'll dedicate a session only two cases, and the two cases which we discussed in the first session of iOS and the Kaisar Jahan Begum and Atar Singh case. I hope you guys all remember these two cases, and these three cases which we will discuss in brief today. We'll discuss all these 5 cases in a separate session, and we'll understand the facts and what was held in this case separately. So in brief, we will understand these 3 cases. So in Vishakha versus State of Rajasthan, this is a landmark case as far as the sexual harassment in workplace is concerned. it was a PIL filed by Vishakha and some other ladies against the state of Rajasthan. So here, up till now, until this decision, until this PIL, there was no laws as far as sexual harassment in workplaces is concerned. So in this case, the new legislation was needed to be formed by the government. Now Supreme Court heard the PIL, and they made certain guidelines, Vishakha guidelines, which is popularly known as Vishakha guidelines, regarding sexual harassment at workplace. What are the guidelines which is to be followed by various companies and various organizations? So the court held that these guidelines would be applicable only till a new legislation is formed by the government or is framed by the government. So if the court would not have been, when this PIL was filed, there was no law as far as the sexual harassment in workplace is concerned. So the court, what they did, they interpreted whatever laws or legislations, Article 14, Article 21, whatever legislations, whatever different acts was there up till now, and then they interpreted those those particular legislations, those particular sections and articles, and they framed the guidelines, and with the help of those guidelines the government formed a legislation which is now applicable in all over India. So first of all, the first is, this is why interpretation is important. So whenever there is no rule as well, then the court interpreted and formed the guidelines which helped in the framing of the legislation. So this is Vishakha versus State of Rajasthan. The second case is Commissioner of Customs and Excise versus Top 10 Promotions Limited. So in this case, why this case is only for the understanding of why interpretation is important. So no draftsman can envisage all the future circumstances which may arise, therefore interpretation from time to time is necessary. I explained this earlier as well, that if I frame a rule today, then 10 years down the line that rule may not be as such valid or may not be applied from word to word. There are some additions or subtractions which must be required, which is required in that particular rule which I am writing down today, which is known as amendment. So there are certain amendments which is done in the rules, in the acts and the legislation. So in this case it was held that interpretation is very much required, and it is a battleground where the judges try and win by interpreting, and it is a very important thing as far as justice is concerned, and it is necessary to do it from time to time, and interpretation is an ongoing process. The third case is Rita Devi versus New India Assurance Company Limited. So the brief facts are that there was an accident which took place. Now in order for compensation, the insurance company said that we are only liable to pay up till the accident part of the incident, the damages to the vehicle or to whatever the damages in the accident that has taken place, or to the vehicle, to the person concerned, but not the murder. We are not liable to pay for the murder or the death that has happened in the course of this accident. But the court interpreted and said that accident will include the word murder, the word death that has happened, and it was considered that not just the payment of the vehicle, but the insurance company is liable to pay for the death that has happened. So the court in this case interpreted the word accident and included murder as in death of the person as well in it. We will discuss these cases and the other two in a separate session, but this was just a brief as to what these cases are and how interpretation is important. Now let us move on to discuss what are the various types of statute. Now we'll discuss various types of statute on basis of some reference. The first is reference to basis of duration, but before that I hope we are clear with what statute is. It is a formal written enactment of a legislative authority that governs a country. Now what do I mean by formal written enactment? Any act. It is an act of a legislative authority. Legislative authority in case of center would be member of parliament, and in case of state would be member of state legislative assemblies. So it is an act, a formal written enactment of a legislative authority, center or state, that governs a particular country. So this is what a statute is, and a statute is applicable for a country or for a state. Okay, now what is the let's move on to the types of statutes here with reference to basis of duration. So what are those statutes? There are two statutes here. The first is perpetual statutes and the second is temporary statutes. Now what is perpetual statutes? It is perpetual when no time is fixed for its duration and such a statute remains in force until its repeal, which may be express or implied. तो ऐसा स्टैच्यूट जिसका कोई टाइम फिक्स नहीं किया गया है, ना ड्यूरेशन फिक्स किया गया है, और वो स्टैच्यूट विल रिमेन इन फोर्स जब से उसको हम एप्लीकेबल मानेंगे, जिस भी डेट से वो एप्लीकेबल होगा इन अ कंट्री उसको हम एप्लीकेबल मानेंगे अनटिल इट इज एक्सप्रेसली और इम्प्लाइडली रिपील्ड. सो अनलेस एंड अनटिल इट इज रिपील्ड बाय सम फॉरेन एक्ट, बाय सम act or by another statute, it is perpetual in nature and it is applicable up till it is repealed. So when no time is fixed for the duration कि वो कब तक applicable होगा, when no time is fixed, that is perpetual statute. And temporary statute is exactly opposite, when a time is fixed कि ये statute कब तक applicable होगा, when a time is fixed, एक specified time है, तो हम उसको temporary statute बोलेंगे, and automatically जब वो टाइम फ्रेम खत्म हो जाएगा, दैट स्टैच्यूट विल एक्सपायर. और वो स्टैच्यूट ऐसा नहीं है कि वो उसी टाइम तक एक्सपायर होगा. सपोज आई हैव मेड अ स्टैच्यूट एंड सेड दैट दिस पर्टिकुलर स्टैच्यूट वुड बी एप्लीकेबल अप टिल 6 months अंटिल आई फॉर्म अ न्यू प्रॉपर लेजिस्लेशन, तो ये 6 months तक रहेगा. जैसे कि वो विशाखा गाइडलाइंस, दैट वाज टेम्पररी इन नेचर. The Vishakha guidelines which we discussed in Vishakha versus State of Rajasthan, that was temporary in nature. तो जैसे ही वो जो गवर्नमेंट है उन्होंने एक लेजिस्लेशन लाया, सेक्सुअल हरासमेंट एक्ट, जैसे ही उन्होंने सेक्सुअल हरासमेंट को लेकर एक प्रॉपर लेजिस्लेशन फॉर्म किया, दोज गाइडलाइंस वर नॉट एप्लीकेबल एनीमोर एज सच कि वो हम रेफरेंस के लिए यूज कर सकते हैं, बट नाउ सिंस लेजिस्लेशन इज देयर दैट पर्टिकुलर गाइडलाइंस इज नो मोर एप्लीकेबल एज सच. सो विच इज टेम्पररी और उसका ड्यूरेशन फिक्स होता है, और वो ड्यूरेशन 6 months तक, सपोज एग्जाम्पल वही कि अगर 6 months तक फिक्स किया गया है, उसके पहले भी हम उसको रिपील कर सकते हैं. जरूरी नहीं है कि 6 months तक ही रहे, उसके पहले भी हम चाहें तो वी कैन रिपील द सेम. नाउ लेट अस मूव ऑन टू द अनदर types of statute. This is the classification with reference to nature of operation. What is nature of operation? How the statutes work, how and when the statutes will work. इस basis पे जब हम classify करते हैं, so this is nature of operation. Now first is prospective statutes. Let us understand this. A statute which operates upon acts and transactions which have not yet occurred when the statute takes effect, that is, which regulates the future, is a prospective statute. So I have made a statute about an incident which has not yet taken place but will take place in due course of time in future. तो उसमें अगर कोई irregularity होगी, that is prospective statutes. Okay? जैसे वो जो लेट्स अंडरस्टैंड दिस, जो सेक्सुअल हरासमेंट का जो केस था उसमें जो स्टैच्यूट बना, तो उसमें बहुत सारे इंसिडेंट्स मेंशन किए गए होंगे कि इस तरीके से होगा तो हम ऐसे एक्ट करेंगे, ये इंसिडेंट होगा, अगर इस तरीके से इंसिडेंट होगा तो हम इस तरीके से एक्ट करेंगे. तो ज़रूरी नहीं है कि सारे इंसिडेंट हुए हुए हों तब तक. तो ऐसा भी है कि कोई इंसिडेंट उस वक्त तक नहीं भी हुआ रहेगा लेकिन इन फ्यूचर होगा. तो अगर वो इन फ्यूचर वाले इवेंट को लेकर कोई हम एक स्टैच्यूट बना रहे हैं, उसको हम प्रोस्पेक्टिव स्टैच्यूट्स बोलते हैं. नाउ व्हाट इज रेट्रोस्पेक्टिव स्टैच्यूट्स? It is exactly opposite of what prospective statute is. Any statute that takes away the vested right which is acquired under the existing laws and it creates a new duty or attaches a new disability in respect of transactions that is already passed are deemed retrospective statute. It's quite simple. Retrospective statutes are those statutes regarding those incidents which have already taken place. तो जो इंसिडेंट ऑलरेडी हो चुके होते हैं उनके बारे में अगर कोई स्टैच्यूट बना है उसको हम रेट्रोस्पेक्टिव स्टैच्यूट्स बोलते हैं. और वो स्टैच्यूट की वजह से दो स्टैच्यूट्स में create a new duty, or they may attach a new disability or liability upon us regarding those particular statutes that are retrospective in nature. What is retrospective? Those events, those things which have already taken place. This is retrospective statute. So prospective was about an event which has not taken place and which might take place in future, and retrospective is about those incidents which have already taken place. This is the continued. The third is directory statutes. A directory statute is generally affirmative in its terms, and it recommends certain acts or omissions but imposes no penalty or on non-observance of its provisions. So directory statutes are mere declaratory in nature. We can say that कि ये ऐसे rules and guidelines होते हैं जिसको स्टेट, एक ऐसा स्टैट्यूट जो रेकमेंड करता है कि सर्टन एक्ट्स को जिसको करना चाहिए और सर्टन एक्ट्स को जिसको ओमिट करना चाहिए, जिसको नहीं करना चाहिए, बट इम्पोजेस नो पेनल्टी, और इसको हम अगर फॉलो नहीं करेंगे तो हमें कोई पेनल्टी नहीं देना होगा. सो एनी स्टैट्यूट जो कि एक बताए कि हमें क्या करना चाहिए और हमें क्या नहीं करना चाहिए, और अगर इस स्टैट्यूट के अगेंस्ट जाके हम कोई काम करते हैं तो हमें कोई पेनल्टी नहीं मिलेगा. दिस इज व्हाट डायरेक्टरी स्टैट्यूट इज. नाउ द एग्जांपल ऑफ डायरेक्टरी स्टैट्यूट इज डीपीएसपी. जो डायरेक्टरी प्रोविजंस हैं जो कॉन्स्टिट्यूशन ऑफ इंडिया में है, दे आर नॉट, दे आर द गाइडलाइंस, दे आर एक्ट्स which a state should do, but if a state does not do it, then there is no penalty on the state. So you cannot hold state liable for not applying, say, Article 44 of the Constitution of India, which is Uniform Civil Code. तो अगर हम ऐसे कल को स्टेट ऑफ बिहार के अगेंस्ट हमें केस कर दें कि आप यूसीसी को नहीं अप्लाई कर रहे हैं, which is not applicable, which is not right, because state is not as such कि state is not it is not imposed upon the state to follow the DPSP. State should follow it. It is affirmative. It is rules which a state should follow, which is required for a welfare state, for a proper functioning of a welfare state. But if a state does not follow it, no penalty can be imposed upon the state. The state is only when DPSP is concerned. Okay. Now the fourth is mandatory statutes. Now what are mandatory statutes? It is one which compels performance of certain acts and directs that a certain thing must be done in a certain manner or form. Now directory statute का opposite हो गया mandatory statute. Mandatory statute is when a performance is compelled. There in directory statutes, the previous one, we said that there are certain rules which one should follow, but if one does not follow, then there is no penalty. However, in mandatory statute, according to this statute, the person is compelled to perform certain acts, and they are directed to do a certain thing or an act in a certain manner which is provided in the mandatory statutes. So let's say if any contract is there, then we have a contractual form that all the parties has to sign the contracts. Consideration must be there. Consideration should be legal. No forced consent should be there. So so this can be said that it is an example. So Contract Act can be said to be an example of mandatory statutes, where they state as to how two parties should enter into a contract. So they compel you to perform the act of entering into a contract into a certain manner or a certain form, let's say. So all those transfer of property act can be say mandatory statutes, because there are certain forms regarding the mortgage, sale. So all those forms are there. So we no matter where, in which part of India we live, we have to follow that particular form which is there in case of mortgage, in case of sale, in case of gift deed, transfer of property, any rent deed, whatever. So this is mandatory statutes, where you are compelled to perform an act in a certain manner which is provided in the statutes. Those are mandatory statutes. An example can be Contract Act, Transfer of Property Act, etc. Now classification of with reference to objective. Now what are the different types of statutes with reference to objective? We'll understand it now. The first is enabling statutes. These statutes are which enlarges the common law where it is too strict or narrow. It is a statute which makes it lawful to do something which would not otherwise be lawful. So it enlarges the common law. With the help of enabling statutes, the area of common law which is already there, the laws which are already there, which is very strict and which is very narrow. Enabling statute, what does it do? It enlarges the scope of common law and it makes some acts which was otherwise not legal, it makes those acts lawful. Okay, so it enlarges the common law where it was too strict and it makes it lawful to do something which was otherwise not lawful. Now disabling statutes, they are opposite of enabling statutes. These statutes restrict or cut down rights existing at common law. So the common law which is already existing, with the help of disabling statutes, some rights might get restricted with the help of disabling statutes. The third is curative or validating statute. Now what is that? It is passed to cure defects in prior law and to validate legal proceedings which in the absence of such statute would be void. So curative or validating statute is when a statute is already there, it is functioning, but there are certain defects. So in order to cure those defects, those curative statute is passed. Now the fourth is repealing statute. We are studying the classification of statutes with reference to objective. The fourth one is repealing statute. A statute which either expressly or by necessary implication removes or terminates another statute is a repealing statute. So if I make a statute which either in a very expressed, in a written down expressed manner, or in an implied manner, it revokes another statute, it repeals or it terminates another existing statute, so then the particular statute which terminated or which revoked the another statute is known as repealing statute. Now the fifth one is amending statute. What is this? Now there are certain statutes with the due course of time, they require amendment, they require certain changes, so that their particular statute which is already existent can work more effectively. So in order to amend some statutes, another statute is formed, and that is amending statute. It is a statute which makes an addition to or operates to change the original law so as to effect an improvement or more effectively carry out the purpose for which the original law was passed. So the basic intention behind amending statute is that the existing statute should work in a more effective manner. So certain changes and defects to be removed and certain changes to be made. Now we've come down to codifying statutes and remedial statutes. Now what are codifying statutes? A statute which presents the statement of law in a detailed and authoritative manner. The object is not merely to declare but to present it in a manner of code. So those particular statutes which presents the statement of law in a detailed and authoritative manner. So the manner in which the statements, the legislation or the statements of law is written down should be authoritative in nature, and the object of this particular type of statutes are not merely to declare, but it should be presented in the manner of code, it should be presented in the manner of authority. So example, CPC and CRPC, these are codes, these are rules which is applied by the courts in case of civil proceedings, in case of criminal proceedings, and these are laws which is applied, these are rules which is applied by the court and the justice delivery process when it is done. So these are the codifying statutes. Now another one is remedial statutes. What are these? these statutes which provide relief when any wrong is done to the party. So when any wrong, if any right has been infringed of a party, then that particular party can claim compensation or damages under what statute? Under remedial statutes, and it is paid, the compensation would be paid by the wrongdoer, obviously. So these are remedial statutes. An example would be Consumer Protection Act 1986. So whenever any right of mine is infringed and I'm a consumer, then I can claim my rights under Consumer Protection Act, and Consumer Forum would, if I am found right, if my rights are actually infringed, if the courts find it right, then they would allow the compensation to be given under Consumer Protection Act. So remedial statutes, those statutes which provide relief when any wrong has been done to the party, and the relief can be in the form of compensation or damages which is paid by the wrongdoer. Now we have come down to the last part of the today's session. With this we would end our session. The penultimate statute, that is the 8th one, is taxing statute. Now what is taxing statute? It is the name is self-explanatory. A statute which imposes tax on the citizens of its country for the welfare of the state and people, and also for generation of revenue for the country, is known as taxing statute. So we pay taxes because India has taxing statutes, because there are rules and regulations and legislations as far as income tax is concerned, as far as taxes is concerned, that is GST, income tax. Earlier there were excise, VAT. So these were the tax. Earlier they were there, now they are repealed and GST is there. So GST is an example of a taxing statute, because of which the people of the country are required to pay taxes, so that it is for the welfare of the state, it is for the welfare of the people, it is for generation of the revenue for the country. So that is taxing statute. Now the last one is penal statute. Now what are penal statutes? Those statutes by the help of which somebody who has committed a crime is given punishment in the form of fine, imprisonment or death penalty. Here the wrongdoer, the property of the wrongdoer may also be taken away for the compensation of loss. So penal statutes are those statutes because of which any person who has done a crime would be given punishment, and the punishment can be in the form of fine, imprisonment or death penalty. Now example of penal statute is very clear: IPC, Indian Penal Code. Because if any person who has committed a crime is given punishment according to the various sections in Indian Penal Code. So with this we conclude today's session. Guys, I request all of you to please listen to this session very carefully, and if you all have any doubts, please write down in the comments below. I will try and clear it out as soon as possible, and thank you very much. See you all in another session. Have a nice day.